The 14th Amendment to the United States Constitution was adopted on July 9, 1868, as one of the Reconstruction Amendments. The amendment addresses citizenship rights and equal protection of the laws, and was proposed in response to issues related to former slaves following the American Civil War. The amendment was bitterly contested, particularly by Southern states, which were forced to ratify it in order for them to regain representation in Congress. The 14th Amendment, particularly its first section, is one of the most litigated parts of the Constitution, forming the basis for landmark decisions such as Roe v. Wade regarding abortion, Bush v. Gore regarding the 2000 presidential election, and Obergefell v. Hodges regarding same-sex marriage. The amendment limits the actions of all state and local officials, including those acting on behalf of such an official. The amendment's first section includes several clauses: the Citizenship Clause, Privileges or Immunities Clause, Due Process Clause, and Equal Protection Clause. The Citizenship Clause provides a broad definition of citizenship, overruling the Supreme Court's decision in Dred Scott v. Sanford, which had held that Americans descended from African slaves could not be citizens of the United States. The Privileges or Immunities Clause has been interpreted in such a way that it does very little. The Due Process Clause prohibits state and local government officials from depriving persons of life, liberty, or property without legislative authorization. This clause has also been used by the federal judiciary to make most of the Bill of Rights applicable to the states, as well as to recognize substantive and procedural requirements that state laws must satisfy. The Equal Protection Clause requires each state to provide equal protection under the law to all people within its jurisdiction. This clause was the basis for Brown v. Board of Education, the Supreme Court decision that precipitated the dismantling of racial segregation, and for many other decisions rejecting irrational or unnecessary discrimination against people belonging to various groups. The second, third, and fourth sections of the amendment are seldom litigated. However, the second section's reference to rebellion and other crime has been invoked as a constitutional ground for felony disenfranchisement. The fifth section gives Congress the power to enforce the amendment's provisions by appropriate legislation. However, under City of Bernie v. Flores, Congress's enforcement power may not be used to contradict a Supreme Court interpretation of the amendment. Text. Section 1. All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall ever state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed, but where the right to vote at any election for the choice of electors for President and Vice President of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and citizens of the United States, or in any way abridged, except for participation in rebellion, or other crime. The basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Section 3. No person shall be a senator or representative in Congress, or elector of President and Vice President, or hold any office, civil or military, under the United States, or under any state, who, having previously taken an oath as a member of Congress, or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each House, remove such disability. Section 4. The validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid of insurrection or rebellion against the United States, or any claim for the loss or emancipation of a slave, but all such debts, obligations and claims shall be held illegal and void. Section 5. The Congress shall have power to enforce, by appropriate legislation, the provisions of this article. Adoption. Proposal by Congress in the final years of the American Civil War and the Reconstruction era that followed. Congress repeatedly debated the rights of black former slaves freed by the 1863 Emancipation Proclamation and the 1865 13th Amendment, the latter of which had formally abolished slavery. Following the passage of the 13th Amendment by Congress, however, Republicans grew concerned over the increase it would create in the congressional representation of the Democratic-dominated Southern states, because the full population of freed slaves would now be counted for determining congressional representation, rather than the 3/5 previously mandated by the 3/5 Compromise. The Southern states would dramatically increase their power in the population-based House of Representatives, regardless of whether the former slaves were allowed to vote. Republicans began looking for a way to offset this advantage, either by protecting and attracting votes of former slaves, or at least by discouraging their disenfranchisement. In 1865, Congress passed what would become the Civil Rights Act of 1866, guaranteeing citizenship without regard to race, color, or previous condition of slavery or involuntary servitude. The bill also guaranteed equal benefits and access to the law, a direct assault on the black codes passed by many post-war states. The black codes attempted to return ex-slaves to something like their former condition by, among other things, restricting their movement, forcing them to enter into year-long labor contracts, prohibiting them from owning firearms, and preventing them from suing or testifying in court. Although strongly urged by moderates in Congress to sign the bill, President Andrew Johnson vetoed it on March 27, 1866. In his veto message, he objected to the measure because it conferred citizenship on the freedmen at a time when 11 out of 36 states were unrepresented in the Congress, and that it discriminated in favor of African Americans and against whites. 3 weeks later, Johnson's veto was overridden and the measure became law. Despite this victory, even some Republicans who had supported the goals of the Civil Rights Act began to doubt that Congress really possessed constitutional power to turn those goals into laws. The experience also encouraged both radical and moderate Republicans to seek constitutional guarantees for black rights, rather than relying on temporary political majorities. Over 70 proposals for an amendment were drafted. In late 1865, the Joint Committee on Reconstruction proposed an amendment stating that any citizens barred from voting on the basis of race by a state would not be counted for purposes of representation of that state. This amendment passed the House, but was blocked in the Senate by a coalition of radical Republicans led by Charles Sumner, who believed the proposal a compromise with wrong, and Democrats opposed to black rights. Consideration then turned to a proposed amendment by Representative John A. Bingham of Ohio, which would enable Congress to safeguard equal protection of life, liberty, and property of all citizens. This proposal failed to pass the House. In April 1866, the Joint Committee forwarded a third proposal to Congress. a carefully negotiated compromise that combined elements of the first and second proposals as well as addressing the issues of Confederate debt and voting by ex-Confederates. The House of Representatives passed House Resolution 127, 39th Congress several weeks later and sent to the Senate for action. The resolution was debated and several amendments to it were proposed. Amendments to Sections 2, 3 and 4 were adopted on June 8, 1866 and the modified resolution passed by a 33-11 vote. The House agreed to the Senate amendments on June 13 by a 138-36 vote. A concurrent resolution requesting the President to transmit the proposal to the executives of the several states was passed by both houses of Congress on June 18. The Radical Republicans were satisfied that they had secured civil rights for blacks, but were disappointed that the amendment would not also secure political rights for blacks, in particular the right to vote. For example, Thaddeus Stevens, a leader of the disappointed Radical Republicans, said, "I find that we shall be obliged to be content with patching up the worst portions of the ancient edifice, and leaving it, in many of its parts, to be swept through by the tempests, the frosts, and the storms of despotism." Abolitionist Wendell Phillips called it a fatal and total surrender. This point would later be addressed by the 15th Amendment. Ratification by the states. Ratification of the amendment was bitterly contested. State legislatures in every formerly Confederate state, with the exception of Tennessee, refused to ratify it. This refusal led to the passage of the Reconstruction Acts. Ignoring the existing state governments, military government was imposed until new civil governments were established and the 14th Amendment was ratified. It also prompted Congress to pass a law on March 2, 1867, requiring that a former Confederate state must ratify the 14th Amendment before said state shall be declared entitled to representation in Congress. The first 28 states to ratify the 14th Amendment were Connecticut, June 30, 1866, New Hampshire, July 6, 1866, Tennessee, July 18, 1866, New Jersey, September 11, 1866, Oregon, September 19, 1866, Vermont, October 30, 1866, New York, January 10, 1867, Ohio, January 11, 1867, Illinois, January 15, 1867, West Virginia, January 16, 1867, Michigan, January 16, 1867, Minnesota, January 16, 1867, Kansas, January 17, 1867, Maine, January 19, 1867, Nevada, January 22, 1867, Indiana, January 23, 1867, Missouri, January 25, 1867, Pennsylvania, February 6, 1867, Rhode Island, February 7, 1867, Wisconsin, February 13, 1867, Massachusetts, March 20, 1867, Nebraska, June 15, 1867, Iowa, March 16, 1868, Arkansas, April 6, 1868, Florida, June 9, 1868, North Carolina, July 4, 1868, Louisiana, July 9, 1868, South Carolina, July 9, 1868. On July 20, 1868, Secretary of State William H. Seward certified that the amendment had become part of the Constitution on July 9, 1868. If withdrawals of ratification by New Jersey and Ohio were ineffective, the following day, Congress adopted and transmitted to the Department of State a concurrent resolution declaring the 14th Amendment to be a part of the Constitution and directing the Secretary of State to promulgate it as such. Both New Jersey and Ohio were named in the congressional resolution as having ratified the amendment. Their inclusion as ratifying states by Congress goes to the merits of rescinding a ratification after it has been affirmed, and of approving a ratification after it has been rejected. It would appear that Congress has determined both have no impact on the ratification process. See Coleman v. Miller. Accordingly, Seward issued an unconditional certificate of ratification, dated July 28, 1868. Declaring that the 14th Amendment had been duly ratified by the requisite 3/4 of the states. During the preceding week, 2 additional states had ratified the amendment, which left no doubt that the amendment had indeed become operational. The 14th Amendment was subsequently ratified. Alabama, July 13, 1868. Georgia, July 21, 1868. Virginia, October 8, 1869. Mississippi, January 17, 1870. Texas, February 18, 1870. Delaware, February 12, 1901. Maryland, April 4, 1959. California, May 6, 1959. Kentucky, March 30, 1976.